Thank you so much, Kathy, and it's a pleasure to be with all of you. It's the middle of March and we are just about to cross into spring. I am excited to be able to bring you a full program today. And so without further ado, if Kathy, you wouldn't mind, please advance to the agenda slide so I can walk the audience through what we intend to cover. Pardon me, everybody. To begin, I'll walk through not only these introductions, but a bit of update for all of you on New York State's budget. Jeff Gleason from our Buffalo office, who's been a regular on our webinar, is back, and he'll be covering March Madness and the things that you need to think about as employers and otherwise those who are managing those office pools. Turns out that there's some law around this that you should know about. Fred Price is on the webinar for the first time. Fred is someone who brings a significant amount of intellectual property background and experience to Bond generally, and is going to be speaking about an aspect that derives from this practice around trade dress registration. I think it'll be really interesting for all of you and a good chance for you to get to know Fred a bit. Jillian Jin is a member of our New York City office who I've had the pleasure of working with now for a while. She both spent her summers at Bond and now is just about to be sworn into the New York State Bar. And so she and I worked on a piece that was published earlier this month concerning network adequacy rules, and she's going to provide a summary of what we wrote about. And then I'll wrap everything up by 12:30. So Kathy, if you go to the next slide, please, let me walk through, and actually the one thereafter, please, what it is that's happening with New York State and its budget. So we are getting to the finish line, perhaps, with New York State's budget. As all of you who tune in know, to the extent you're regular in following what happens with the budget, and of course it matters so much. The budget by law is supposed to be signed by April 1st by the governor. That sometimes happens, sometimes does not. And it has been the governor's habit, if that can be fairly described, over the course of her tenure, sometimes to extend that timing on signature for the purpose of continuing to negotiate. We'll see whether that happens this time around. There's some open issues that I thought were worth raising. One includes cell phones in schools. The governor would like to essentially prevent students, in schools, high schools, et cetera, from having their phones around at any time other than before and after class. There's some pushback. We've had some deeper dive discussion on that here on the webinar. We'll see whether this survives. The governor is also looking to make some changes to discovery laws. There have been some adjustments in previous legislative cycles in the last few years. She's interested in seeing some shifts back that essentially would unwind some of those changes. There is some debate over that presently. Involuntary commitment is another one of those issues that the governor brought up in her State of the State, and there isn't unanimity on where that lands right now. So we'll see. Interestingly, in her State of the State, the governor also talked about essentially rebate checks for New Yorkers. The Senate is looking to narrow who receives those, keeping those to older New Yorkers specifically. We'll see how that lands. Human services organizations are in the moment, part of the discussion around whether their cost of living will be elevated, and how much. That is, an annual conversation, and this year it's getting some traction. In the healthcare realm, which of course is adjacent, where I do a lot of my work, there are questions around whether that managed care organization tax, which I've discussed here previously, it's essentially a one-time inflow of federal monies. California also received something comparable, and at the end of the President Biden administration, there was approval for that to happen in New York State. Exactly how that gets sliced and diced is a big part of the discussion right now, in particular how it relates to healthcare delivery. Relatedly, there are talks around bringing back more money for Vital Access Provider Assurance programming, which is essentially monies for healthcare organizations in distress. There are activities around whether cannabis and the industry that supports burgeoning in New York State gets more formal funding, as well as enforcement, given some of the so to speak rogue actors that have been part of what has been the struggle to get the industry off the ground. So a lot of activity and debate around there. One thing that is interesting in terms of not being in the budget, and specific in the One House bills, the Consumer Directed Personal Assistance Program, excuse me, we talked about this year on the program before. It's set to move, essentially into a consolidated form as of April 1st. There was some thought that, either the Senate or Assembly would push back on that and argue that delay is appropriate. We do not see that. There's ongoing litigation, however, that may ultimately lead to that same outcome, but that will not be part of the budget process. So that is the snapshot for now. By the time I'm back in front of you next, we'll see, but it's likely we'll know what's going on with the budget in more formal ways. And for the moment, we just wanted to give you this on-the-fly update. So thank you very much, Kathy, for a few moments to do so. And let me now introduce our next speaker. And that is Jeff Gleason. Jeff is someone known to all of you. He has been on our program a number of times over to discuss things, including casinos and other aspects of his really diverse practice. Jeff is also someone who's a fan of March Madness personally, but also thinks about it as a lawyer and has some tips for all of you to make sure you manage this well and have some fun at the same time. So Jeff, let me turn it over to you. Thank you for joining us from Buffalo, and the floor is yours.
Thank you, Gabe. Kathy, if you want to progress to the slides. So with all due respect to the December holidays, March is the most wonderful time of the year. As Gabe said, I'm a big fan of March Madness, and if you've never immersed yourself in the excitement of the tournament, I would suggest you do so. So with that said, next slide, please. So obviously there's a lot of excitement around it. I mean, we call it March Madness. There's a lot of excitement and anticipation built around the men's and women's NCAA basketball tournaments. There is an entire day called Selection Sunday, which just picks the people who are going to be in those tournaments. And so you can see this anticipation, this excitement building. A lot of offices and businesses turn to this to either encourage kind of office camaraderie and planning bracket pools, or maybe they reach out and want to do promotions with their clients or customers. However, as Gabe alluded to, there are risks involved in these. There are gambling laws that are implicated here, which carry possible criminal law penalties. There's also other restrictions that we'll talk about a little bit here. Obviously, bracket pools are one of the commonly known practices at this time of year. We're going to talk a lot about those bracket pools. I want to talk just quickly about a couple things we're not going to address that deeply. First is contests. Contests are usually viewed as the submission of something, a work of art, a drawing, an article, and then the winner is selected based on some subjective criteria that is identified at the beginning. We're not talking about contests. We're also not talking about really general promotions, which is just trying to draw customers to your business through advertising or maybe even a contest. But this is a little bit different. We're talking about a bracket pool where usually somebody is turning in an entry fee or something, and the person who selects the most games correctly wins the prize. So if we can advance to the next slide, I'll point out a couple of things that really make that problematic. First is the definition of gambling under New York law. We're only going to talk about New York law here today. Obviously, every state has a different set of statutes that deal with gambling. But in New York, an act constitutes gambling when a person stakes or risks something of value on the outcome of a contest of chance or a future event not under their control, under an agreement that they will receive something of value upon the happening of that event or the occurrence of a certain outcome. Think about this in the context of sports. I'm going to pick UConn to beat Syracuse, and if UConn beats Syracuse, I'm going to win something. A lottery is a little bit different. A lottery under New York law is an unlawful gambling scheme where a person agrees to pay something of value for chances to win another thing of value as a prize. A raffle of sorts. I'm going to buy tickets, and each of these tickets is a chance to win that larger prize. Also kind of problematic if you don't have a license to to conduct a gambling operation. You don't have a license to conduct a lottery. And the problems with these really go to the criminal law. New York penal law it criminalizes gambling, and it is either a Class A misdemeanor with a maximum penalty of 1 year in prison and 3 years probation, or in some instances a Class E felony with a maximum penalty of 4 years in prison and 5 years probation. So obviously we want to stay away from those things. Next slide, please. So let's talk a little bit about, again, the elements of gambling. When we're talking about bracket pools, we're talking about consideration given for participation. The winner is determined based on the happening of some event of chance, and then a prize with value. A lot of people look at bracket picking or filling out a bracket as involving some skill. You got to know what who these teams are. You got to identify the teams that could upset a higher seed and all of that. But really, the identification of Cinderella teams doesn't make this a game of skill. A lot of people will think back to the New York arguments around daily fantasy sports and how at first that was classified as a game of skill, which would allow the staking of monetary consideration on those events. That's not what's at play here. These really are games of chance. So we can't really think about eliminating the element of chance from that consideration. Next slide, please. But one of the things we can think about is modifying the way that a business conducts a bracket pool, either for its employees or for its customers or clients, which would comply with law. We have two other prongs of this analysis that we can look at. First, eliminating consideration. Obviously, if an employee or a group of employees or a group of customers are able to complete a bracket for free, and still you conduct the bracket pool the same way, whoever receives or whoever picks the most winners, or you can have a point system or whatever, that person wins the prize or benefit. You've eliminated consideration, prize is still given, you now have a compliant bracket pool. You can also eliminate the prize. That kind of defeats the purpose of businesses seeking promotion. If you're having people actually pay something to submit a bracket, but they don't actually win anything, you might get some engagement, but you're not really, you're almost leaving a sour taste in the mouth of your participants, because where did that money go? But prizes, again, we want to think about other kinds of prizes that we could give in your traditional bracket pool. They might win all the money that was staked by the participants, but if you are a business thinking about running one of these bracket pools, you should probably avoid cash prizes. Think about gift cards for your employees. Those are frequently used. Also, particularly if you're dealing with customers or clients, you might think of swag from your business as the prize that the winner receives. Next slide, please. So we talked a lot about kind of how to make your bracket pool compliant. If you are set on having a bracket pool there that involves the staking of an entry fee or consideration for participation, you're going to still offer a prize. It's obviously still based on chance. There are ways in which you can run that kind of bracket pool. It comes with a lot of additional legal concerns. It comes with the idea of posting official rules. It could vary into the territory of sweepstakes, in which you have bonding requirements, you have registration with various states, Department of States, you have various reporting requirements. Certain non-for-profit agencies might be able to conduct what we call charitable gaming, but those also come with these additional concerns. If you intend on hosting a bracket making promotion that does not eliminate one of those elements of gambling, as we talked about in this presentation, you should be aware of these. You should consult legal counsel, but really, kind of if you're doing this kind of for fun, again, to encourage employee camaraderie or to offer promotion for your business, you should really think about not running a bracket making promotion that involves all three of those elements. One last thing on the next slide, please. One next thing to be aware of when you're running a promotion, you need to be aware of the trademarks that are at play here. The NCAA has registered March Madness as a trademark. They are vigilant about protecting those trademarks. They've also got additional trademarks associated with the basketball tournaments, Final Four, Elite Eight, the Big Dance. There's a number of other trademarks and design marks that they have claimed protection of. And if you're going to use their marks to promote your business, you might be getting a letter from the NCAA.
Jillian, though, is someone who has, again, been with our office now in New York City for some time. I've enjoyed working with her. And she took a close look at these new network adequacy provisions, which we will address in brief here. There's a fuller piece that Jillian and I authored, which you can get from us directly if you didn't receive it in your email inbox already. But Jillian, welcome from the New York City office and welcome to the webinar.
Hi, everyone. It's nice to be here today and to speak to you all. As Gabe mentioned, my name is Jillian, and I'm an associate trainee in the New York City office. Today, I'm going to be talking about the new network adequacy standards that the governor recently announced. Next slide, please. So first, for some background, network adequacy standards refer to requirements for health plan networks that aim to improve access to services and healthcare providers. So in short, these standards ensure that these networks have enough healthcare providers to meet their members' needs. This past February, the governor announced new network adequacy standards for New York State. Now, these standards primarily focus on strengthening the mental health care system by expanding access to behavioral health services. I'm going to note this on a later slide, but behavioral health services are broadly defined as mental health services and substance use disorder treatment services. Next slide, please. So these new standards will be enforced by the New York State Department of Financial Services and the State Department of Health. The state DOH will enforce these standards for HMOs. So that would include Medicaid managed care plans and the New York State Child Health Plus and Essential Plan. Now, on the other hand, the state DFS will be responsible for enforcing these standards for commercial health insurance plans. Now, as I mentioned, these new standards primarily focus on behavioral health services. So it's applicable to any health plan network that contracts with behavioral health agencies who ultimately provide the mental health and substance use disorder treatment services. Next slide, please. These new standards will be effective July 1st, 2025. I want to note that this is not an exhaustive list, but these are the biggest changes that networks should be aware of. So first, there is going to be a change in standard wait times. So members have to be given an initial appointment for behavioral health services within 10 business days or within 7 calendar days following a member's discharge from a hospital or emergency room visit. If that timeline can't be met, then the member needs to be referred to an out-of-network provider at a cost to the member that does not exceed the in-network rate. Networks also need to update their directories to include more specific information about their in-network behavioral health agencies. So this information would include their practice location, scope of their services, linguistic competencies, whether they offer telehealth appointments, and more. Lastly, networks need to have an access plan in place that details how they monitor and compile data regarding the behavioral health agencies within their network. As of now, networks are expected to certify their compliance with all these new standards by the end of 2026, but it's important to note that this will be an annual obligation moving forward. Next slide, please. So these new standards apply to health plan networks, but they present a unique opportunity for behavioral health agencies. So for one, BHAs can negotiate a new contract if they believe their network does not meet these new standards. On the other hand, BHAs can negotiate new contracts with plans they are already in network with. Lastly, BHAs can position themselves as an out-of-network resource for other plans.
Let's switch to Fred Price, who is here again, first time on the webinar, but someone who has a really deep well of knowledge in the intellectual property space. And it's an opportunity for all of you to learn from Fred about trade dress registration. It's a really interesting topic that as we're just talking about at the end of the preceding presentation, various elements of intellectual property that are at play. They're everywhere, and so it's good to be thinking about them. Fred, the floor is yours. Welcome from our Syracuse office. We really look forward to hearing what you have to say to that.
Thanks, Gabe. And even though my background shows San Francisco, certainly I am in Syracuse, unfortunately. But today I'll be talking about providing a high-level summary of trade dress, which is a type of intellectual property protection. First slide, Kathy, please. So trade dress. Let's talk about what is trade dress. It's a subcategory of trademark law, and you can register trade dress at the USPTO. And it protects distinctive non-functional look and feel of a product design, shape, or 3D configuration. So that's opposed to patent law, where patent law will cover some of the utilitarian features and functionality. So consider, you can see this bottle here, the overall look of the bottle and the shape and the length and width of this bottle could be covered by trade dress. And the way the cap fits and connects to the top, including the grooves here and how it snaps off to this piece here, that would be covered by utility patent. So that's a high level difference of the two types of IP. And trade dress acts as an indicator of source and to identify and distinguish goods of one company versus another, which of course can benefit both consumers and manufacturers. And it can be a supplemental type of IP protection. In other words, you can have copyright protection, patent protection, and trade dress protection. Or it can actually act as an alternative to other types of IP protection where, for example, patent protection may not be available. The rules and regulations of patent law are very finicky. So there are a lot of what's called statutory bars to obtaining a patent. And if those are in place, then you can possibly seek trade dress protection. So rights, what type of rights are conferred by trade dress? Well, number one, you can prevent others in the United States and or importing into the US a confusingly similar trade dress design in conjunction with the same or similar goods. You should be able to prevent others from federally registering the same, meaning if someone else files an application, a trademark examiner will review that application and do a review of what's been filed or registered at the trademark office. And if they see something similar, they will reject and not allow that application. And a giant benefit of trade dress is it's potentially unlimited in time. If you meet certain requirements, including consistent and exclusive and continuously use, and of course, periodic payments at the USPTO. So for my first example, unfortunately, you can't see it, but I can describe it to you. Any other children of the 90s, or if you grew up in the 90s, you know what Doc Martens look like. They actually have a trade dress for their the shape of the sole and the color of the sole, with a dark line on top, with a lighter line on the bottom, and then longitudinal ribbing on the sole itself. They have a trade dress on that look and feel. And of course, if you see anybody wearing those, you know they had Doc Martens back in the day, and they're of course at least someone I would want to hang out with. Not sure about everyone else, but certainly love those boots, and they're still protected to this day. Another example I had was 3D configuration. It's a figure 8 shape of a razor handle. And lastly, and maybe most popular, is the Milano cookie. The configuration covered there were 2 oval-shaped cookies with a chocolate sandwich filling inside, and then a notch depicted on top on an otherwise flat surface. 2 main requirements of getting a trade dress registration. First is non-functionality. In other words, it can't be essential to the use or purpose of the article, or if it affects the cost or quality of the article. In other words, it can't just be the sole of a shoe or a handle of a razor or a use of a low-cost plastic composition. And evidence weighing against the finding of functionality can include the showing of existence of alternative designs. So, for example, consider the multitude of existing razor handle shapes, including cylindrical with a constant diameter, or flat, and the size narrows as you get closer to the neck. There are a number of, probably infinite number of designs for a handle shape. And if you can show that to the trademark office, the more likely it'll be considered non-functional and ornamental only and probably registerable. Second main requirement of obtaining registration is acquired distinctiveness. What does this mean? Well, the product configuration seen by consumers must make them think source first rather than the product itself. And evidence of acquired distinctiveness can include, number one, 5 years of exclusive and continuous use of that design. Number two, advertising prominently highlighting and focusing and directing consumers to the unique product configuration. And number three, and this is the most, could be difficult to get, but certainly weighs in favor of registrability, is declarations from multiple consumers that when they see your product design, they think you as the source. So that's a really quick run through of trade dress.
Kathy, you go to the next slide. There you are, or there is the set of contact information that it was Fred mentioning just a moment ago that it would be an easy way to reach him. You can reach Jeff, you can reach Jillian, you can also reach me. We're here to help, so please do not hesitate. We have gotten to the bottom of the hour, so I'll wrap up this program. We appreciate your commitment and loyalty as always. Just a bit of a brief programming note. I won't be with you either next week or the week thereafter due to a little bit of a scheduling juggle. So Carrie Langan will be the host those 2 weeks. I'll be back with you once we cross fully into mid-April, and I look forward to that very much. In the meanwhile, wishing all of you a terrific afternoon and enjoy those first days of spring just around the corner. Thank you again.